Okay, we're back on the record. Your name again, please.
Joe
Mr.
Van
Claiborne. Thank you. Good morning, Mr.
Joe.
Claiborne. Did you speak with an attorney this morning, sir?
Yes, I did.
Thank you, Mr. Claiborne. You're here for case number 200555159, People State of Michigan versus Joe Von Claiborne, counselor.
Mr. Chairman, on behalf of the defendant, Mr. Claiborne, Your Honor, my client waives formal reading, understands constitutional rights, and stands guilty.
Court waive formal reading on her plea of not guilty. Mr. Claiborne, you have two court dates that you must attend. Both will be held via Zoom. You have a probable cause conference August the 12th on a Wednesday. You have a right to a preliminary examination following Wednesday, August 19th. Both at 8:30 a.m., 36th District Court in front of Judge Wagner. You'll get information on how to connect for those court dates from the officers in the detention center. Is that understood?
Yes.
Thank you. Not guilty is entered as the bond.
Your Honor, my client is 46 years old. He's a lifetime resident of Michigan. He does have medical conditions. He does take medication. He has completed his GED. He understands the seriousness of these charges and allegations. He also, understands the consequences of not attending the next court date. Your Honor, I'm respectfully asking the court for a personal bond given the pandemic as well and the non-assaultive charges.
Thank you. Officer Marcus, file medical, please. Mr. Claiborne, these are very serious allegations. They are non-assaultive. Court takes consideration the allegations set forth as well as the information investigators report provided by your counsel, current epidemic facing the nation, your incarceration status as it relates to the ability to post bond, given lack of employment, as well as your prior criminal convictions. During this bond, Mr. Claiborne, there's no use of alcohol, no marijuana, no illegal controlled substance, and you're not to purchase or possess a firearm or any dangerous weapon. Given the information placed on the record, bond is $10,000 personal bond. You have a personal bond on this matter, Mr. Claiborne. Good luck. I hope all works out well.
Okay.
Welcome. Okay. Thank you, DDC, for your accommodations. And you have Kenneth Jackson, correct, counsel?
Yes, that's correct, Judge.
Are you representing him on just the felony matters or on the misdemeanor allegations as well?
Just the felony matter. It's kind of complicated. We were already assigned.
No worries. You don't got to explain everything. I will just handle it. Who's in front of us? Your name, please?
Kenneth Jackson.
Thank you, Mr. Jackson. Thank you, officers, for paying attention. I appreciate that. Mr. Jackson, you're here for a couple of reasons, sir. You have your attorney that is on the screen to your right. First, we're going to handle some matters, Mr. Jackson, where you have warrants for your arrest on unrelated misdemeanor allegations where your counsel is not representing you on these allegations. We'll get to the allegations, the felony controlled substance allegations in one moment. First, on these allegations, these misdemeanor charges, Mr. Jackson, did you read, sign, and understand an advice of rights form? He has retained counsel on this one.
Yes, sir.
Thank you, Mr. Jackson. You're here before the court because you have warrants as stated for failing to appear at the 36th District Court. On these matters, you're going to be released on these on a personal bond. Very important, you attend a pretrial on August the 24th. That is a Monday, 8:30 a.m., 36th District Court in front of Judge Sabri. Is that understood?
Yes, sir.
And those matters on August 24th will be heard via Zoom, which is an off-site streaming technology. You'll get information from the officers before you're released on how to connect, but that's your responsibility. Is that clear?
Yes, sir.
Thank you. Mr. Jackson, you're here for ticket number SX3616508, September 30th, 2019. Drive while license suspended, revoked, denied. Bond's $240 personal bond. During this bond, sir, there's absolutely no driving. Is that understood?
Yes, sir.
Thank you. Ticket number SP1027861, September 24th, 2019. No insurance misdemeanor on an '08 Chevy. Bond $240 personal bond. And ticket number 194579581, November 5th, 2019. Count 1, no operator's license in possession. Count 2, no insurance misdemeanor on an '08 Chevy. Bond's $480 personal bond. These allegations, Mr. Jackson, are all misdemeanor charges carrying up to a $500 fine and/or 93 days in jail as a maximum fine and penalty. Court, recall the warrant, set aside capious, enter plea of not guilty. As a reminder, we have a Zoom hearing Monday, August the 24th. That's going to be separate than the court date that we're about to handle. So the court date with your attorney is not going to be on the 24th. That's your responsibility to attend that hearing separately. Is that clear, Mr. Jackson?
Yes, sir.
Okay, good luck on these allegations, sir. I hope it works out well. Not guilty, please entered. And you are here with counsel regarding case number 200588421, People State of Michigan versus Kenneth Jackson. Counselor.
Yes, good morning, Your Honor. Jonathan Borders, P78948 on behalf of Mr. Kenneth Jackson. I come from Neighborhood Defender Service of Detroit, which is the local public defender's office. I know this is not going to be a standard arraignment, and I apologize for the extra time I'm going to take here. This is an odd case in that I am not retained. We are appointed to this case.
I apologize. Go
There
ahead.
was some kind of error at Mr. Jackson's original arraignment where the arraigning judge did not process his paperwork correctly. I have an assignment from assigned counsel services that indicates that Mr. Jackson was arraigned on July 3rd, 2020 already on this case, and that he was granted a personal bond in that instance. I received a phone call last night at 9:30 indicating that Mr. Jackson was under arrest, and I rushed down to the Detroit Detention Center with my paperwork to try to secure his release, which ultimately was unsuccessful and why we're here this morning. So I don't know how the court wants to handle this in terms of the arraignment. I think we can redo it safely, but I just did want to give the court the background that Mr. Jackson has already been arraigned in front of Judge Linda Mack on.
That's concerning for a number of reasons. And what was the bond on that matter initially?
It's a $5,000 personal bond, and I can share my screen to show the court my assignment if it wishes.
No, you're officer of the court. Court finds you credible. And so, counsel, I guess my understanding is you just want to go forward with the new arraignment. Is that correct? And I'll recall any warrants at this point in time, and we'll set new court dates and then a bond. Is that your understanding?
I think that's probably the safest way to handle this to make sure it gets done correctly.
Okay. Thank you, counsel. And again, this is 200588421, People State of Michigan versus Kenneth Jackson. As to the arraignment, counselor?
Yes, Judge. With respect to the arraignment, my client waives the reading of the information, and he stands mute to the charges.
Court waive formal reading and enter a plea of not guilty, recalling any warrants or capious as previously placed on this matter. Mr. Jackson, on this matter, sir, the court is scheduling a probable cause conference. This will be held via Zoom as well, and it's scheduled August the 19th, which is a Wednesday. 8:30 a.m., 36th District Court in front of Judge Giles, held via Zoom. You understand, Mr. Jackson?
Yes, sir.
Not guilty is entered as the bond.
Thank you, Your Honor. And then as the bond, again, I'm asking the court to instate a $5,000 personal bond, which was the bond that was granted to him on July 3rd in his original arraignment.
Thank you. Is he on probation for the unarmed robbery?
Judge,
Are you on probation or parole, Mr. Jackson?
No, sir. I ain't been in trouble in 4 years, sir.
Okay, Mr. Jackson, it's very important you attend that court hearing as stated, and during this bond, there's no use of alcohol, no marijuana, no illegal controlled substance, and you're not to purchase or possess a firearm or any dangerous weapon. Is that understood?
Yes, sir.
Thank you. Mr. Jackson, the court takes into consideration all the information provided by your counsel, your ties to the community, serious nature of these allegations, which are non-assaultive, the current epidemic facing our nation, your employment status as it relates to ability to post bond. The court has concerns regarding your prior capious history, which tells the court you do not appear as ordered on unrelated matters. But given the information provided by your counsel, bond on this matter will be set in the amount $8,500 personal bond. It's going to be a personal bond, Mr. Jackson. The court has concerns regarding your prior capious history. Make sure and attend that court hearing, both court hearings, so you don't get locked up just for not showing up to court. Does that make sense?
Yes, sir. I will.
Good luck, Mr. Jackson, and counsel, thank you for your patience. Appreciate it. Have a nice day.
Thank you, Judge, and I've made a note of both of those court hearings, and I'll be in touch with Mr. Jackson.
Thank you.
Thank you.
Appreciate it. Thank you, officers at DDC.
You're welcome.
Finally hitting smooth waters, I think. They had a little rough bounce there, bouncing all around. Good morning, your name, please?
Milton Hunter.
I apologize, your name one more time?
Milton Hunter.
Vincent?
Hunter.
Milton.
Milton Hunter.
Milton Hunter.
Yes, correct.
Okay, thank you. That's one we don't have, right? Wait, here's some more. Oh, okay. No, you're good. Good morning, Mr. Hunter. You're here for case number 200592021, People State of Michigan versus Milton Hunter, also known as Milton James Hunger, Milton James Hunter. Counsel.
Mr. Chairman, on behalf of the defendant, Mr. Hunter, my client waives formal reading, understands the constitutional rights and stands guilty.
Court waive formal reading of the information, enter a plea of not guilty. Mr. Hunter, the court scheduling a probable cause conference, sir, that you must attend on August the 19th, which is a Wednesday. That's 8:30 a.m., 36th District Court in front of Judge Jones. Mr. Hunter, that court date will be held via Zoom. That's an off-site streaming technology. You'll get information before you're released on how to connect. Yeah, you're pointing like a phone. You could do it on a phone. It's also on a computer, but it's your responsibility to connect August 19th. Is that understood? 8:30.
That's understood.
Thank you. Thank you. Not guilty is entered as the bond.
Your Honor, my client is 35 years old, lives in Detroit his whole life. He has no priors. This is a non-assaultive charge. He's self-employed doing home renovation. He's a complete talent. He's got great community ties. He lives with his wife and 3 kids for reasons 1 through 5 and given the pandemic as well. I'm respectfully asking the court to consider a personal bond. Again, this is a non-assaultive charge, and he does understand the importance of making his next court date.
Thank you. Mr. Hunter, the court takes consideration the serious nature of this allegation, non-assaultive, lack of capious history, lack of criminal convictions, current epidemic facing the nation. The information provided by counsel as well as your employment status as relates to ability to post bond. During this bond, Mr. Hunter, you are not to purchase or possess a firearm or any dangerous weapon. Is that understood?
Yes, sir.
Okay. It's very important you attend that court hearing, Mr. Hunter, so you don't get locked up just for not attending. Does that make sense?
Yes, it does.
Your bond's $10,000 personal bond. You're being released, Mr. Hunter. Good luck. I hope it works out. Listen to the court, sir.
I appreciate it.
You're welcome.
Next up.
Good morning, Your Honor.
Good morning, sir. Your name, please.
Brandon Robinson, sir, and I'm innocent.
Thank you, Mr. Robinson. We'll enter a not guilty plea when we get there. You are here for case number 200592018, People State of Michigan versus Brandon Robinson. Counselor.
Justice, I'm on behalf of the defendant, Mr. Robinson. My client waives formal reading, understands the constitutional rights, and stands guilty.
Court waive formal reading of the information, enter a plea of not guilty.
I have the video to prove it.
Mr. Robinson, this is your attorney speaking. Everything you say is being recorded. I advise you for your own good. Please do not say anything. Do not discuss any facts. It is being recorded. So please, this is just purposes of arraignment. Just listen for your next court date. And if you have any questions about bonds, once that's addressed by the judge in the court, we will answer those questions, okay?
Okay. Yes, ma'am.
Thank you. Thank you both. Not guilty, please entered. Mr. Robinson, the court is scheduling a probable cause conference, sir, that you must attend on August the 19th, which is a Wednesday, 8:30 a.m., 36th District Court in front of Judge Archer. That matter will be held via Zoom, Mr. Robinson, which is an off-site streaming technology. You'll get information from the officers before you release on how to connect, but that's your responsibility to connect on time. Is that understood?
Yes, sir.
Thank you, sir. Not guilty plea is entered as to the bond.
Your Honor, for bond, co-counsel has to cover this due to the conflict.
Oh, I'm sorry. I signed the wrong one.
You gave him a personal, right? Yeah.
Oh, I get it. Yeah, okay. Sorry. Nice to
Don't mind that other stuff.
Okay.
Hey, man, I'm sorry. Did we do Mr. Robinson yet?
Nope, we're just waiting for bond arguments.
Okay. Yeah, I talked to Mr. Robinson this morning. Mr. Robinson tells me that this is a case retaliation. Mariah Moore Johnson is his stepdaughter. He has a 3-year-old with her mom. He called Child Protective Services on her mother because she leaves the kids at home. He stays at another location, has to come watch the kids on several occasions. So when he called Child Protective Services, the mother made up these allegations of child abuse against, or forced her 14-year-old to make these allegations up against my client. Judge, my client has no prior assault or convictions. He's 38. He has 3 college degrees. He has 3 college degrees. I don't believe he's a flight risk. I don't believe he's a threat. He obviously will not have any contact with Mariah Moore Johnson, his stepdaughter. I'd ask the court to consider personal bond for Mr. Robinson, that he will return for all these court dates, Judge, and I don't believe he's a flight risk.
Thank you. Mr. Robinson, this is a very serious assaultive allegation. The court has concerns regarding your prior felony criminal convictions, as well as the allegations which are assaultive alleged in the investigator's report. You have ties to the community. The court takes consideration of positive information provided by the counsel, including employment status as it relates to the ability to post bond. Current epidemic facing the nation. Mr. Robinson, during this bond, there's no use of alcohol, no marijuana, no illegal controlled substance, and do not to purchase or possess a firearm or any dangerous weapon. Is that understood?
Yes, sir. And I got my evidence to prove my innocence. Yes, sir.
And I appreciate that. Mr. Robinson, the court's inclined to release you on a personal bond. You have to listen to the court so you don't get locked up for not listening. And not only are you to make that court hearing, no weapons, but you're not to go to the premises or area of 19132 Sunset, Detroit, Michigan. Is that understood?
Yes, sir.
Thank you. And Mr. Robinson, as stated by counsel, absolutely no contact with Mariah Moore Johnson. That means no contact of any kind, orally, in writing, through a third person, at her place of residency, or any forms of social media. Absolutely no contact. Is that clear?
Yes, sir.
Counsel, do you want to address a GPS tether?
Judge, I would ask the court for personal bond. If the court wishes to have a tether added, obviously, I can't stop that, Judge. I would ask the court, if the court's inclined not to do a tether, because the court is, I would ask for GPS tether that gives personal bond.
Mr. Robinson, you're going to listen to the court, no contact. You have another residency to stay at, is that correct?
Where I've been staying at, yes.
And it's my understanding he has not been staying with them at all, Judge.
Okay,
and that's my house. But
Mr. Robinson, that's not your residency during this time because the court ordered you not to go there. So that train of thought needs to be shifted for a brief moment while you're on this bond. You are not to go back to that location, regardless of who you believe the owner may be. It could very well be yourself, but the order of the court is not to go back to the residency.
I understand correctly.
Do you have any issues with that?
No, I will stay in my apartment.
Thank you, Mr. Robinson, and the court appreciates that you have another place to stay. The information provided by our counsel. For these reasons, the court set in bond in the amount $14,000 personal bond. You're being released on a personal bond, Mr. Robinson. The court's not going to place a tether on you at this point in time. You have to listen to all orders of the court so you don't get locked up for not listening. Does that make sense?
Yes, sir.
Good luck, Mr. Robinson.
Thank you very much, Your Honor.
Yep. Welcome.
Thank you, everyone.
Welcome. Good morning. Your name?
Knowlton.
Good morning, Mr. Knowlton. Mr. Knowlton, you're here for case number 200-45247, People State of Michigan versus Ahmad Rashad Knowlton, also known as Ahmad Knowlton Counsel.
Good morning, Your Honor. This is Mr. Knowlton. Your Honor, my client was formal reading understands his constitutional rights and stands to be.
Thank you. Court will waive formal reading of the information under plea of not guilty. Mr. Knowlton, you have a pretrial date, sir, that you must attend on Wednesday, August 19th. That's 8:30 a.m., 36th District Court in front of Judge Bryant. Mr. Knowlton, that matter will be heard via Zoom, which is an off-site streaming technology. You'll get information from the officers before you're released on how to connect, but that's your responsibility to connect on time. Is that understood? Not guilty is entered as the bond.
Your Honor, my client is 39 years old, lived in Detroit his whole life. He lives with that, he has no prior felonies. He is employed with Pan Landscaping. He just authorized his taking medication for high blood pressure. He does understand the seriousness of the allegations and the consequence of not appearing for his next court date. This is a non-assaultive charge. I am asking the court respectfully to consider a personal bond.
Thank you. Mr. Knowlton, is a very serious allegation, sir, but it's non-assaultive. The court's inclined to release you on a personal bond. You have to listen to all orders of the court, sir, including making your court date and not going back to the area or premises of any Meyer store during this bond. Is that understood?
That's understood.
Thank you, Ms. Knowlton. Given the epidemic facing our nation, the information provided by counsel, lack of criminal convictions or KPS history, ties to the community, bond will be set $5,000 personal bond. You're being released on a personal bond. Do not go to Myers. You have a hearing August the 19th on a Wednesday via Zoom. Good luck, Mr. Knowlton.
Thank you.
Welcome. Yes, ma'am. Good morning, your name?
Markeith Jones.
Good morning, Mr. Jones. Mr. Jones, you're here before the court on case number 200-59020. People State of Michigan versus Markeith Stephen Jones. Counsel.
Good morning, I represent on behalf of the defendant, Mr. Jones. My client wishes for a motion to understand the constitutional rights and statutes.
Thank you. For a way formal reading of the information and her plea of not guilty, Mr. Jones. Court scheduling a probable cause conference, sir, that you must attend Wednesday, August the 19th. That's at 8:30 a.m., 36th District Court in front of Judge King. That matter, Mr. Jones, will be held via Zoom, which is an off-site streaming technology. You'll get information from the officers before you're released on how to connect, but that's your responsibility to connect on time. Is that clear?
Okay. Yes, it's clear.
Thank you, Mr. Jones. Not guilty, please enter. That's at the bond.
Your Honor, my client is 21 years old, and he lives in Detroit his whole life. He has no prior. He is unemployed. He's a student at Wilson State University. He's a senior. He takes a few medication. He lives with his mom. He's got great community ties. This is a non-assaultive charge. And with the no priors, I am asking the court to consider a personal bond.
Thank you. Mr. Jones, this is a very serious felony allegation. However, the court is taking into consideration you have no prior criminal record the court's aware of. You've never missed a court date that the court's aware of. You have ties to the community, as stated by counsel, current epidemic facing our nation. During this bond, Mr. Jones, you're not to purchase or possess a firearm or any dangerous weapon. Absolutely no weapons, understand?
Understood.
And if the court releases you on a personal bond, Mr. Jones, you're going to listen to the court, show up on those dates on the 19th of August on Zoom. Is that correct?
Yes, how would I get the link, or how would I?
As stated at the beginning of the agreement, the bond on this matter, for the reason stated, $7,500 personal bond. Before you're released, Mr. Jones, you'll get that information from the officer, but that's your responsibility to connect on time on the 19th. If you have any questions, that needs to be hammered out before the court date and time. Is that clear?
Okay, it's clear.
Good luck, Mr. Jones.
Thank you.
Your Honor, how much was his bond again? I'm sorry.
No, I apologize. $7,500 personal bond.
Okay, thank you.
You're welcome. Good morning, your name?
Larry Dudley.
Good morning, Mr. Dudley. You're here for case number 200-58283, People State of Michigan versus Larry Dudley.
Good morning, Your Honor. Judge Bichab, on behalf of the defendant, Mr. Dudley, Your Honor, my client, who is formal reading, understands his constitutional rights and stands guilty.
Court waived formal reading of the information under plea of not guilty, Mr. Dudley. The court scheduling 2 court dates, sir, that you must attend them both. Probable cause conference on August the 5th, which is a Wednesday. You have a right to a preliminary examination the following Monday, August the 10th, both 8:30 a.m., 36th District Court in front of Judge Jones. Both matters, Mr. Dudley, will be held via Zoom. That's an off-site streaming technology. You'll get information from the officer before you're released on how to connect, but that's your responsibility, if you're able to be released, to make that court date via Zoom on time. Is that understood?
Yes, sir.
Thank you. Not guilty plea is entered. As to the bond.
Your Honor, my client is 61 years old. Appears he turned himself in just a couple of weeks after the incident date back in 2019. He he has a prior, but it's from 1979, Your Honor. Given he is employed at utility contractors, and Your Honor, given the pandemic as well, I'm respectfully asking the court to consider a personal bond.
Thank you. Mr. Dudley, are you on probation or parole?
Yes, probation, sir.
Is that for the domestic violence?
Yes, yes.
Is that against is that against Miss Peach's body as well?
This Peach's baby, yes.
Beatty, okay. So, Mr. Dudley, that's very concerning. You've had numerous priors, though counsel's named one. You've had at least 2 prior assaultive convictions for domestic violence, making this a 3rd offense. You're on probation, as stated by yourself, for a domestic violence conviction against this against this same victim. You have a conviction, as stated by counsel, for criminal sexual conduct in 79, a conviction for criminal sexual conduct 1st degree in 86, a conviction for felonious assault in 2014. You have numerous prior, at least 5 prior felony or assaultive, not felony, 5 prior assaultive convictions. And the court's very concerned that you're on probation for assaultive conviction against the same victim, Miss Peach's body. The court takes into consideration that you have no capious history. One moment. You have ties to the community. The court considers the current epidemic facing the nation, employment status as stated by counsel as it relates to ability to post bond. Also concerning is the allegations investigators report, which include presence of a threat. It indicates you pulled a knife and allegedly threatened to cut the individual. And also concerning is that you allegedly fled to a residence before police arrived. You are being recorded. Anything you say will be used against you. You have an attorney present. Is there something? You're raising your hand. What's going on?
Yes, Your Honor. I had, like my attorney told you, I had turned myself in, right? And I haven't done nothing since I turned myself in. I found employment with a company that's just like DTE Energy. They gave me a chance, even with my background. They say they're going to give me one shot to become a good employee at their company. I've been working since July 13th, not doing nothing but working. They alcohol test you, they drug test you to be employed with this company. And since I had this job, July 13th, I haven't been doing everything right, trying to stay employed. I haven't paid taxes. I haven't paid taxes since in over 30 years. This is the first time I had an income where I'm paying into the system.
Mr. Dudley, thank you for all that information. The court will, hoping will take that into consideration. I did tell the court, I don't know if you were able to hear me, that you are employed there. So again, Your Honor, given all the facts that I stated and that the defendant has just made, I would respectfully ask the court again to consider a personal bond given all of the facts that were just stated on the record, Your Honor.
Thank you, counsel. Mr. Dudley, that is positive information that the court does take into consideration, as well as your employment status as it relates to ability to post bond. And good luck with your employment, Mr. Dudley. I hope that works out well. The court has concerns for the reasons stated, your prior felony convictions, the serious nature of this allegation. During this bond, Mr. Dudley, there's no use of alcohol, no marijuana, no illegal controlled substance, and you're not to purchase or possess a firearm or any dangerous weapon. Is that understood?
Yes, sir. Yes, sir.
And officer, please mark Mr. Dudley's file medical for the reasons stated by counsel. And Mr. Dudley, during this bond, you are not to go to the premises or area of 9176 Greenfield, C3, Detroit, Michigan. Also, absolutely no contact with Peach's body. No contact means no. Okay. No contact means no contact of any kind, orally, in writing, through a third person, at Miss Beatty's residency, employment, or through any forms of social media. No contact with Peach's Beatty. Is that clear, Mr. Dudley?
Yes, sir.
And if you're able to make bond, you're to be fit with the GPS tether. Does your probation officer know about this allegation?
Yes, because I turned myself in. I report it every week, sir.
Thank you.
Would you please reconsider?
Well, I haven't even given a bond yet. The bond for the reasons stated is $5,000, 10%. That's a $500 bond, Mr. Dudley. Good luck, sir.
That's my brother.
You're welcome. He has 2 court dates, probable cause August the 5th, preliminary examination August 10th, both in front of Judge Jones. You're welcome. Good morning, your name, please.
Lawrence, CA.
Good morning, Mr. CA. You're here for case number 1905570, People of State of Michigan vs. Lawrence, CA. Counselor.
Jessica Sharon, on behalf of the defendant, CA, Your Honor, my client was formal reading understands the constitutional rights and stands in the
Thank you. Court waive formal reading of the information under a plea of not guilty. Schedule 2 court dates, Mr. CA, that you must attend them both. A probable cause conference on August the 12th, which is a Wednesday. That's at 8:30 a.m., 36th District Court in front of Judge Archer. You have a right to a preliminary examination following Wednesday, August 19th. That's at 1:30 p.m., 36th District Court in front of Judge Archer. Mr. CA, both of those matters, court dates will be held via Zoom, which is an off-site streaming technology. You'll get information if you're able to be released from the officer on how to connect, but that's your responsibility to connect on time. Is that all understood? Do you understand those court dates, Mr. CA?
Yes.
Thank you. Not guilty is entered as the bond.
Your Honor, my client is 62 years old. He has no priors. He lives in Detroit his whole life. He's a father of 5. He lives with his daughter. This incident is from 2018. He was a caregiver up until March, which is when the pandemic started. Your Honor, I'm respectfully asking the court to consider a personal bond.
Thank you. Mr. CA, these are very serious assaultive allegations and are alleged assaultive on a 10-year-old child, and that's very concerning to the court. Court takes consideration the ties to the community, the information provided by counsel, the current epidemic facing the nation, lack of cases history, criminal convictions, employment status as it relates to the ability to post bond. Mr. CA, during this bond, you are not to purchase or possess a firearm or any dangerous weapon, and absolutely no contact with Layla Hawkins. And that means no contact of any kind, orally, in writing, through a third person at their place of residency, employment, or through any forms of social media. Absolutely no contact with Miss Hawkins. Is that understood?
Yes.
Is Miss Hawkins still residing at the 9729 Bellatier Street?
Yes.
So you're not to go to that premises or area of 9729 Bellatier Street, Detroit, Michigan. Is that understood? Do not go to that location or area. Thank you. Given the concerns the court has, serious nature of these assaultive allegations, age of the net matter, lack of criminal convictions, bond will be set. $20,000, 10%. Good luck, Mr. CA. It's $2,000, sir. Good morning, your name, please. Good morning, sir. One moment. Mr. Small, you're here for case number 20058-019, People State of Michigan versus Jermaine Antonio Small, identified in the complaint as defendant 2. Counselor.
Mr. Chairman, on behalf of the defendant, Mr. Small, my client reads formal reading, understands the constitutional rights, and stands in the
Court waive formal reading the information under plea of not guilty. Mr. Small, the court scheduling 2 court dates, sir, that you must attend both. Probable cause conference on August the 5th, which is a Wednesday. You have a right to a preliminary examination August 10th, following Monday. Both 8:30 a.m., 36th District Court in front of Judge Jones. Both matters, Mr. Small, will be heard via Zoom, which is an off-site streaming technology. If you're able to be released from DDC, you'll get information before you're released on how to connect, but that's your responsibility to connect on time, August 5th, August 10th. Is that understood?
Yes.
Thank you. Not guilty, please entered as to the bond.
My client is 40 years old. He's a lifetime resident of Detroit. staying with his sister since he lost his house. He's helping care for his mother and father. It appears that he was in the hospital with chest pain when he was brought in, taken into custody. He has a GED. Trying to get on disability, Your Honor, and I'm respectfully asking the court if we can consider a personal bond or what the court finds to be reasonable.
Thank you. Mr. Small, court takes consideration that serious allegations, assaultive allegations before the court. You have a lengthy prior felony convictions, which the court takes into consideration, including assaultive convictions, which make this allegation, life allegation, mandatory 25-year sentence. The allegations before the court are extremely serious. Court notes the current epidemic facing the nation, employment status as it relates to ability to post bond, lack of case history, the very serious assaultive allegations laid out in the investigator's report. Mr. Small, during this bond, sir, you're not to purchase or possess a firearm or any other dangerous weapon, and absolutely no contact with Deontay Devon Mason. No contact means no contact of any kind, orally, in writing, through a third person, at their place of residency, employment, or through any forms of social media. Absolutely no contact. Is that understood?
Yes.
Thank you. And he's unemployed, is that correct, counsel, you say?
Yes, sir.
Given the information placed on the record, your prior criminal convictions, bond will be set. $200,000 cash surety. Good luck, Small.
Your Honor, August 5th is from a board judge.
Both in front of Judge Jones, August 5th and August 10th. So the Division 1 never called us back? You want to try him one more time? For Nate Laylock? Thank you, officer.
My time.
Thank you. Good morning, your name, please.
Jerome Haven.
Good morning, Mr. Havis. Good morning. You're here for 200-59017, People State of Michigan versus Jerome Havis, also known as Jerome Demetrius Havis. Counsel.
Your Honor, Dr. Charles, on behalf of the defendant, Mr. Davis, my client is for a reading understanding of constitutional rights and stands you.
Thank you. Court will waive formal reading information under a plea of not guilty. Mr. Havis, the court scheduling 2 court dates that you must attend them both. A probable cause conference on Thursday, August the 6th. Mr. Havis, you have a right to a preliminary examination the following Tuesday, August the 11th, both at 8:30 a.m. at the 36th District Court in front of Judge Archer. Mr. Havis, both of those court dates, August 6th and August the 11th, will be heard via Zoom. That's an off-site streaming technology. You'll get information from the officer before you're released on how to connect, but that's your responsibility to connect on time. Is that understood?
Yes, sir.
Not guilty. Thank you, Mr. Havis. Not guilty is under death to the bar.
Your Honor, my client is 31 years old, lives in Detroit his whole life, no prior assaultive conviction, does receive, for disability. He did finish the 12th grade, he's got great community ties, and respectfully asking the court to consider a personal bond. He understands the consequences if he misses his next court date. He understands the seriousness of the allegations, and due to the pandemic, they're blind, respectfully asking the court to consider a personal bond.
Thank you. Mr. Havis, this is a very serious allegation. It's an assaultive allegation. The court has concerns regarding your prior felony convictions, which include a conviction for robbery armed, and that's a same charge before the court. The court notes that that allegation before the court is a life offense. It's very concerning regarding the safety of the public, as given the information alleged in the investigator's report. Appears you have ties to the community, given the epidemic facing our nation and the information provided by counsel. Mr. Havis, during this bond, you're not to purchase or possess a firearm or any dangerous weapon, and absolutely do not go to the premises or area of 20526 Steel, Detroit, Michigan. Is that understood?
Yes, sir.
Thank you, Mr. Havis. Thank you. And you're also to have absolutely no contact with the alleged victim Leangela Watts, no contact means no contact of any kind, orally, in writing, through a third person, at her place of residency, employment, or through any forms of social media. Absolutely no contact with Miss Watts. Is that clear?
Yes, sir.
Thank you, Mr. Havis. The allegation investigative report indicate you allegedly pointed a handgun, taken property, and then allegedly that did not belong to you, and allegedly fleeing the residence, and that's concerning to the court regarding your intention to appear and handle this matter. Given information placed on the record, concerns the court has, epidemic facing the nation, bond will be set, 75,000 cash surety. Good luck, Mr. Havis.
Man, can you talk to the judge real quick, bro? Judge, bro, this girl is lying, man. She living at my house right now. That's my house. She live with me. She from Kentucky. She ain't even from up here. It's her gun. It's her gun. She has the gun. It's her gun.
This is your attorney speaking. This is your attorney speaking. I understand that you're frustrated. I just need to remind you and advise you that this is being recorded. Everything you say can be used against you in the future.
It's her gun. It's her. She has the gun.
I will advise you to stop talking. This is being recorded. You will have an opportunity to speak to your attorney before your next court date. This is the arraignment.
The court entered a not guilty plea, Mr. Havis. Yes.
We entered a non-guilty plea. This is the court entered a not guilty plea.
I can't afford 75,000 cash and surety.
The court took into consideration your employment status as a...
Your Honor.
I don't have an employment status. I get disability.
This is your attorney.
Understood.
Let me speak to
Lack
the
of.
court, please. Your Honor, I do understand that the court has made their decision and respect that, Your Honor, but with the court, we will need to consider a bond.
Based on what reason?
Your Honor, he does get disability, he can't post bond. It seems that there's a lot of, there are allegations at this point, Your Honor. I understand the court is concerned. However, it's his house, he has another place to stay, he'll be able to stay somewhere else, Your Honor, but if we have an ability to at least post bond for his next court date. He is unemployed because of his disability, so I hate for him to have to stay just because he doesn't have the money because of his disability, Your Honor.
And
If the court would respectfully reconsider a different bond.
the court took into consideration all the information stated, his lack of employment status as it relates to ability to post bond. This allegation is a life offense. One of the allegations is a life offense. He's previously been convicted of same offense of robbery armed. This is a very serious assaultive allegation. The court took into consideration his lack of employment status as well as the current epidemic facing the nation. The concerns the court has not only regarding his prior felony conviction, but the investigators' reports alleged that he pointed a handgun at the alleged victim, took property not belonging to him, and then fleeing the residence. The bond was set for the reasons stated in the court.
Again,
these are just allegations.
Everything is being recorded. The judge is speaking. We can't speak over him. Everything is being recorded. It will be
for the court placed bond and feels appropriate for the reasons stated. Yes, Mr. Havis.
Your Honor, I did not point no gun at that girl, man. That girl, I cheated on her, bro. The girl in Pittsburgh, bro. She's trying to lock me up, man.
Mr. Havis, this is just an allegation. The court entered a not guilty plea. The court entered a not guilty plea. You're presumed innocent, as always. And these are just allegations, Mr. Havis, and the court takes into consideration.
Sorry, Your Honor. You will have the opportunity to speak to your attorney before your next court date. These, again, are just allegations.
I don't have $75,000 to get out of jail.
Okay. Anything further, Mr. Havis? The court took into consideration your lack of employment status and set bond appropriate.
So what am I supposed to do to come up with $75,000?
Your Honor, I'm sorry, Your Honor. Again, respectfully, I know the court makes a disability. A GPS tender.
I can add one, but the dollar amount staying the same.
No, thank you, Your Honor.
Okay. Anything further?
No, thank you, Your Honor.
Good luck, Mr. Havis.
Yeah, somebody can try first. Oh, she's trying to put that video stand on my foot.
And that outburst is another reason that the court feels comfortable with the $75,000 charged with armed robbery. Officer, any males at 48 hours? Meet you on the female side. Take that as a no.
Yeah, there's so much going on there. What was the date in front of what they're doing?
The dates on those matters were 2 court dates. Probable cause conference on August the 6th. Preliminary examination August the 11th, both 8:30, both in front of Judge Archer. You're welcome. Yep. 1 second. Let me just go off the record.
They said they're at lunch and they can do it at 1 o'clock.
2:30.
We told them we don't start back up until 2:30, and she said, whoop, give 1 minute.
Well, no, hold on, I'm gonna tell you.
Sorry, okay.
We do this at 2:30. Oh, no, you do a good job, thank you.
Don't worry about it, just do what you got. Me.
We'll always have 1 female, but on this one. No, you're fine. This one we did the big one. I had like certain how it worked. So they kept calling in and calling in.
I didn't read that file. What's going on now?
I wasn't because I was trying to catch up on you. That's why I called you, because I was thinking that they were just calling the wrong port.
She lives there.
So finally answered it.
And I understand that.
He said, we're ready.
She said, obviously, allegations.
We're ready now. I said, well, where do you have to log in?
We got it.
We're not.
Calm down.
Call back in 5 minutes.
And his date, luckily, like, I understand that being there is not.
Whatever. Then he
It's
just
not
called back.
far out.
And they said, we're busy, we're doing other things. And then we just called, they never called back. And then we just called back again. They said, we're at lunch, we'll do it.
So silly, you don't work, especially with someone very, escort.
They just flipped up their hands.
Exactly.
And then they
So
just.
you have to make a
Right.
record.
Yeah.
Yeah, well, I didn't either. I just said, hey, I'll make 5 minutes. You know, we'll give us 5 minutes. So I just kept going. I had an NBOC. They called right in at 11. I did that. I had an attorney. They called right in. We did that. We never called back. So I just had to call them. They said, no, we never called back. No, I called again 10 minutes later. 15 minutes. I said, where are they? They said, we're doing other things.
I don't know.
And then I said, we'll call them again.
Are we able to call on that? Instead of that done?
Yeah, I mean, I called it, you know, I called it. He's already called.
I mean, they should have been ready at 10:30. I told them to call back in 5 minutes. They didn't call back a couple of times. I'm just gonna put it on the record and say it's good. All right, thanks. How'd your day go?
I mean, I wasn't a very big fan, honestly, but I don't know why it was not that. I do only get into the class, so I think that
And also, we got one attorney that we had for Kevin Johnson. We have one that he called before.
I can't wait.
No, it's not really going on. No, okay. I mean, I didn't get his email.
I mean, I'll let you.
You know, we called on the phone.
Your name is Chief is legendary. If you can fix that, you don't have to do nothing else.
I don't even remember his name. Just the Wayne contact. Oh, wait, but we, yeah,
Good work. Awesome. Thank you. Good work. So, look, you're gonna go on the record real quick, okay? You're gonna go on the record real quick. All right, this is Magistrate Complaint regarding Nate Blaylock. This was scheduled for a 10:30 hearing. It's my understanding that the officers were attempting to call into the courtroom prior to 10:30. I answered the phone probably around 10:25 with Officer Love present, instructed them to call back 5 minutes once we started the docket and got information and the files squared away. They have not called back. It's my understanding Officer Love attempted to call them back within the hour after 10:30. They indicated to Officer Love that they were handling other arraignments. It is now 12 o'clock. They have not called back. Officer Love again attempted to call back about the status of Mr. Blaylock. They have never, according to the court, have called since the 10:25 phone call. They instructed Officer Love that they were at lunch and wanted to do the matter at 1 o'clock, is my understanding. Is that all accurate, Officer Love? Thank you. We're going to hear this matter at 2:30. Officer Love, could you tell them that it's at the 2:30 docket, please? Thank you.
Thank you, officer.
Yep.
Do you remember getting the name of the retained counsel we had for?
Oh, man.
Do you remember his name,
I even thought about writing it down and I didn't. I'm sorry. I wonder if Phil's got it. Sometimes they. What?
I'll ask him.
Sorry, Claudia. I'll write it down on the sheet. 2:30 is when we start. We'll be ready at 2:30.
Okay, we'll be ready at 2:30. 2:30, yeah. Yep, my time is good. Okay.
Thank you, officer.
It's too much.
All right, so everybody, first next time?
Good morning, Miss Powell. One moment, ma'am. State your name one more time, please.
Tanisha Powell.
Thank you, Miss Powell. Miss Powell, you're here before the court on a couple of reasons. We'll get through them one at a time. First, did you read, sign, and understand an advice of rights form today?
Yes.
Thank you, Miss Powell. First, we're going to handle some matters. We have warrants for your arrest for failing to appear at the 36th District Court, and that's on case number 085613911. October 4th, 2008. Failed to display valid license not on person. Count 2. Same day, time, and location, unregistered motor vehicle. Both of those matters, Ms. Powell, are going to be dismissed based on the age of the ticket. Memorandum of understanding between 36th District Court, State of Michigan. The court is dismissing both of those charges against you, ma'am, and waiving any warrant fees. On each of those dismissals, you have a $45 clearance fee. $45 on each charge. That's $90 total. You have to pay that as soon as possible. Do you understand?
Yes, sir.
Thank you. And you're also, Ms. Powell, here regarding case number 12058-128, People State of Michigan versus Tanisha Virginia Powell. Counsel.
Good afternoon, Your Honor. Jessica Shah on behalf of the defendant, Ms. Powell, Your Honor, my client, Ms. Grover, reading on the stand for constitutional rights and stand.
Thank you. Court will waive formal reading of the information under a plea of not guilty. On this matter, Ms. Powell, you have a pre-trial date you must attend on August the 19th. That's 8:30 a.m., 36th District Court. That's a Wednesday in front of Judge Bryant. Do you understand?
Yes, sir.
Thank you, and Ms.
You
Powell.
said
August the 19th, which is a Wednesday, August 19th. And you'll get this information before you're released. And on the 19th of August, that is going to be heard via Zoom. That's an off-site streaming technology. The officer will also give you information on how to connect for that hearing via Zoom on August 19th. But that's your responsibility to connect on time. Is that understood?
Yes, sir.
Not guilty, please entered as to the bond.
Your Honor, my client is 34 years old, lives in Detroit for her whole life, is unemployed due to the pandemic. She did 2 years of college. This incident did occur 9 years ago, Your Honor. So I'm respectfully asking the court to consider a personal bond. She knows the seriousness of these charges and the consequences of not appearing to her next court date.
Thank you. Ms. Powell, it's very important you listen to the court. You seem to fail to listen when ordered to come to the court, and that's very concerning. You have capious history for failing to appear not only on the prior matters, but on this matter as well. When you failed to appear on this matter, the judge issued a warrant for your arrest and placed $2,000 cash surety bond. The court is going to take into consideration the current epidemic facing the nation, the information provided by counsel, the authority we have regarding amendment of bonds, the information before the court, lack of criminal convictions or allegations of assault, ties to the community, employment status as stated by counsel as it relates to ability to post bond. During this bond, Ms. Powell, no alcohol, no marijuana, and no illegal controlled substance. Do you understand?
Yes.
And you're not to purchase or possess a firearm or any dangerous weapon. Absolutely no driving, period, and no drinking of any alcohol, period. Is that clear?
Yes.
The court's inclined to release you on a personal bond, Ms. Powell. Listen to the court so you don't get locked back up just for not listening. Does that make sense?
Yes.
For the reasons stated, bond on this matter set in the amount $14,000 personal bond. And that is given the information placed on the record. The court does not have the benefit of any investigator's report. Officer, do we have any males or females at 48 hours that can't wait till the afternoon?
No, thank you, Your Honor.
Thank you. Appreciate your help. Have a nice afternoon, sir.
Yes, sir. We move it on. So those are gone. We gave you 14.